All right, we're on the record on State versus Loyd. Mr. Loyd is present with his attorneys. He's in custody, attired in a blue cardigan, pink shirt, no tie, civilian pants. He does have on shackles and jail shoes. They can't be seen by the jury from any angle in the courtroom because his feet are underneath the table. All right, I have the final penalty phase jury instructions. Any additional corrections, State?
No, Your Honor.
Defense? All right, and verdict form, same thing. Anything additional?
No.
All right. All right, let's pass out the instructions to the jury. And we'll bring them in. While we're doing that, since the email, this is the email that was sent to me by Mr. Lenham, and it was sent to everybody, about the expert that you brought up, Mr. Ridgway, and you had concerns about it. Since it was discussed, I'm just going to go ahead and make it part of the record, so the record's clear about what we were talking about. You ready? All right, let's bring the jury in. State recognized presence of the jury.
Yes, ma'am.
Defense. All right. Good morning, folks. Welcome back. As I indicated, both sides have now rested as to the penalty phase. You've each got a copy of the penalty phase jury instructions, just as I did in guilt phase. I'm going to read you part of these prior to the attorneys doing their closings, just so that I've instructed you on the law and the process that is followed in reaching a verdict in this case. The attorneys will then do their closings, and I'll read you the remainder of them. You'll retire to consider your verdict, all right? Again, these are yours. You can make notes on them. You'll be able to take them back into the jury room with you. Members of the jury, you have heard all the evidence and the argument of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crimes of murder in the first degree and/or killing of an unborn child by injury to the mother. There are two possible punishments. One, life imprisonment without the possibility of parole, or two, death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proving aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: 1, the defendant was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation or parole. 2, the defendant was previously convicted of another capital felony or of a felony involving the use of threat or violence to the person. The crimes of battery on a law enforcement officer, murder in the first degree as to your consideration of the sentence on count 2, killing of an unborn child by injury to the mother as to your consideration of the sentence on count 1, attempted first-degree murder and attempted felony murder are felonies involving the use or threat of violence to another person. 3, Sade Dixon's unborn child was a person less than 12 years of age, as to count 2 only. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a verdict form to make this finding as to each alleged individual aggravating factor, and you should indicate whether or not you unanimously find that aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility for parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find the existence of at least one aggravating factor and that the aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider is the existence of any factor in Markeith Loyd's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factors that you have unanimously found exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven aggravating factors and proven mitigating circumstances, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that any aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous, and your decision to impose a sentence of death must be unanimous. You will be provided a verdict form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that a jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, did the witness's testimony agree with the other testimony and other evidence in the case? 6, had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 8, has the witness been convicted of a felony? The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant exercised a fundamental right by choosing not to be a witness in the penalty phase. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the penalty phase. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. I'm going to stop at this point, ladies and gentlemen. I'll read the remainder to you after the attorneys have done their closings. So at this time, both sides have an opportunity to address you.